Good morning, everyone. Rob Morella from the New Jersey Dog Bite Lawyer here. If a dog bites you in New Jersey, you might assume the whole case comes down to one question. Was the dog dangerous? That sounds reasonable, except in New Jersey, that's not actually the main fight. Because New Jersey law is very favorable to dog bite victims. This catches people off guard. A case can go sideways fast. Not because the law is bad, but because the facts get messy. Maybe the bite wasn't reported properly. Maybe there's confusion about who owned the dog. Maybe the defense argues that you weren't supposed to be on the property. Maybe they say you provoked the dog. Maybe you waited too long to get treatment, and now we have messy records. So in this video, I want to break down how the New Jersey dog bite law actually works, where people misunderstand it, what tends to make these cases stronger or weaker in the real world. One of the biggest mistakes, treating it like a legal problem first, when it's actually a medical and an evidence problem. Let's start with the basic rule. In a classic bite claim, the injured person usually has to prove three things. 1, that the defendant owned the dog. 2, that the dog bit the plaintiff. And 3, that the bite happened while the plaintiff was in a public place or lawfully in a private space. Right away, you can see why some cases are clean and some get weird. Because if all three things are easy to prove, the case is often in a strong position on liability. But if even one of those factors starts to get fuzzy, the defense suddenly has room to work. For example, maybe everyone agrees that there was a dog, but whose dog was it exactly? Or maybe everyone agrees it was the owner's dog, but now the argument becomes, were you actually permitted to be there? And the third issue matters more than people think, because lawfully on private property is broader than a lot of people realize, but it's still something you have to prove. What does lawfully there actually mean? Think about people like a delivery driver, a repairman, a postal worker, a guest, somebody dropping something off, or someone entering an area that they could reasonably believe was covered by an invitation. Lawful presence can include someone who was expressly invited in an implied sense, or even there to perform some sort of legal duty. That's why this part of the case becomes practical, because if the defense wants to muddy the water, they might not argue the law first. They may argue the facts. They may say, you weren't supposed to be there. You had no reason to go in that area. You overstayed an invitation. Or you wandered in an area that you weren't supposed to be. Suddenly, a case that seemed simple now depends on evidence that you should have saved on day one. The text inviting you over, delivery confirmation, the Uber record, the Ring camera footage, things that prove that you had permission to be at the location where you were. This stuff matters. Now, here's another important distinction. The dog bite statute is strongest when there's an actual bite by the owner's dog. That sounds obvious, but it matters because people say dog bite case when the injury wasn't technically from a bite. Maybe the dog knocked somebody down. Maybe there was a scratch. Maybe there was a caused fall down due to fear of being attacked. Those cases can still be serious and can still be valuable, but they don't necessarily fit neatly into the dog bite statute. That means common law theories like negligence or knowledge of dangerous propensity or behavior, they start to matter a lot more. One of the first questions in any of these cases was, is it actually a dog bite? Because if it is, New Jersey's very plaintiff friendly. If it's not, you may still have a case, but the path gets a little more fact sensitive. And then there's another nuance that people miss. A bite does not necessarily require broken skin. The defense can say, come on, it wasn't a real bite. Look, there's not even any blood. Look, there's not even a scar. But that's not really a mic drop. The defense will still, even in a dog bite case, look to find fault in the plaintiff. Comparative negligence can, in some circumstances, matter. They could argue that you unreasonably exposed yourself to a known risk. They could argue that you provoked the dog or that you ignored warnings not to pet the dog or go near where the dog is. Or that you handled the dog in a way that created the problem. And yes, that can matter even where the statute is otherwise favorable. This is especially important because people hear strict liability and assume that their own conduct is irrelevant. That's not true. If the defense can build a believable story that you helped cause what happened, that can reduce your damages. In some cases, it can bar recovery if your fault is found to be greater than that of the defendant. So, from a practical standpoint, one of the dumbest things a person can do after a dog bite is give the defense a theme. Things like, oh, I knew the dog was mean, but, or I was kind of messing with him. I thought he was bluffing. I ignored that warning sign because I didn't think it mattered. That is not being honest in a helpful way, unfortunately. You're actually building the other side's argument to defend against you. And if the injured person is a dog professional like a groomer, a boarder, or a trainer, that doesn't automatically kick you out of the statute. But based on their experience, the warnings that they received, their knowledge of the propensity of the dog, and how they handled the dog can become a very big issue in the case. What about landlords? A lot of people also assume that if a tenant's dog bites someone, that the landlord is automatically liable. It's not that simple. New Jersey generally does not treat landlords and other third parties the same way it treats the dog's owner under the dog bite statute. These cases usually live and die on negligence principles. That raises a whole bunch of new questions. Did the landlord know about the dog? Did the landlord know that the dog was dangerous? Did the incident happen in an area under the tenant's control or in a common area to the property, like a yard, a courtyard, a hallway? Was there enough knowledge of the dog to create a duty on the part of the landlord? This matters. People love to point to a lease and say, aha, no pets allowed. But a no pets clause by itself does not automatically make the landlord off the hook for the purposes of insurance. So if you're dealing with a landlord, an apartment complex, a business, or some other third-party owner, the case may still be viable, but it's going to be different from a simple dog bite case. Timing matters. Let's talk about some deadlines. For ordinary injury actions in New Jersey, the statute of limitations is 2 years from the date of the injury. But if a public entity or a public employee is involved, the incident occurred on public property, the dog was owned by a police department, there is a much different set of rules. We're subject to what's called the New Jersey Tort Claims Act. We must place any public entity that may or may not be involved on notice within 90 days of the incident. If you fail to meet that deadline, you may be barred forever from bringing your claim. There are notice requirements, there are timing restrictions, there are damages limitations. There is no strict liability judgment against a public entity or a public employee. And pain and suffering recovery can be limited unless certain thresholds are met in the case of a public entity. Let's talk about what actually makes these cases strong. In the real world, leverage matters because when we prep these cases, we take a case assuming it's going to go to trial. What are we looking for at the New Jersey Dog Bite Lawyer? We're looking for clear liability. We're looking for no credible provocation defense, or strong medical documentation. Unfortunately, a visible or lasting injury, and we're looking for insurance coverage. That's the perfect combo. If you want to maximize your case's value, the first step isn't that glamorous. Treat your bite. Go to the hospital. Visit the orthopedic if you're having bodily injury pain. Go to the plastic surgeon, have your scar reviewed. Document, document, document. Take the ugly photos. I know it's embarrassing, but you have to do it. Otherwise, there's no documentation. It's like a tree falling in the forest that nobody heard. Don't ignore the emotional harm. Log down the fear of dogs that you're feeling, the subsequent experiences that you've had around dogs, childhood anxiety, changes in behavior on the part of a child who's been bitten. Do a little bit of research. Find out if the person whose dog bit you owns their home. Report that to a lawyer as soon as possible. You can help us help you if you do a little bit of legwork. The reality is that settlement value depends on whether or not there's coverage and how much that coverage is. There are some things that raise value in cases, and then there are some things that hurt value. Scarring, hand injuries, infections, nerve or tendon involvement, surgeries, painful symptoms, and documented psychological harm are value drivers. What can hurt value? Delayed treatment, no formal bite report, you forgot to call the police, weak proof of dog ownership, weak proof of the fact that you had permission to be at the location. Those things can really hurt your case. What's the big takeaway? New Jersey law can make fault easier than in some states, but the money still follows the proof. Not the outrage, not the breed, the proof of what happened. So if you remember nothing else today, remember this. New Jersey dog bite law can be very favorable to an injured person, but it isn't automatic and it isn't idiot-proof. The strongest cases are usually the ones where the law is good and the facts are clean. And if that case involves a child with facial injuries, hand injuries, surgery, disputed ownership, disputed lawful presence, landlord issues, common areas, businesses, or any other public entity angle, the stakes go up fast. If you're facing a dog bite case in New Jersey, don't hesitate to reach out for a free consultation. We will answer all of your questions and make sure that you are on the path to recovery and a fair settlement.